Unfair language 2. A definition of disability that pays benefits only if you can't perform each and every material duty of your occupation. This language shows up in many disability insurance policies, and for good reason. Courts have decided that this language means you'll be paid benefits only if you can't perform every duty of your regular occupation. If, for example, you're a journalist and you're not able to travel to be with people or even type at a computer, but you can still read, you wouldn't be considered disabled from your occupation because you could still be able to perform at least one of the duties of your occupation. In one case, the physical requirements of an assistant manager of a computer information systems position included using a personal computer, talking on the phone, and attending meetings. This employee was frequently required to sit, stand, and walk, but because of an injury, he wasn't able to stand for long periods of time. Unfortunately, the job couldn't be performed by alternating sitting and standing. His employer agreed that he was limited to a small amount of work in one day. The doctor said, "Okay, you can work 3 hours in an 8-hour day." Before his injury, he worked 40 hours per week at a fairly physical, non-taxing job. His injury limited him to 3 hours per day. Unfortunately, he was insured under a disability policy that only paid him benefits if he couldn't perform each and every substantial duty of his occupation. The insurance company argued that since he could perform even one material duty, working for as little as 3 hours per day, he wasn't disabled and therefore not entitled to disability benefits. The scary part of this story is that the court accepted this argument. The court stated that even though such a definition of total disability is extremely restrictive and not a disability policy that a prudent consumer would be expected to purchase, the plain language of this plan commands the result. Under ERISA, there's no oversight over limitations on coverage a long-term disability insurance company can put into your policy. Since there's no requirement that benefits be provided in the first place, there's no rule against providing almost unattainable benefits. At the hearing, the judge suggested that this was like a coma policy. That is, it was only a policy that would pay benefits if you were in a coma. The judge said that while it might seem unfair that this policy paid nothing, he pointed out that the employer had paid all the premiums. The employee was free to purchase his own less restrictive disability policy, but he didn't do so. If the employer wanted to protect its employees against anything but the most serious and terrible disabilities, then it could have purchased a better policy and paid higher premiums. Since this employer didn't, the employee was stuck with the terms of the policy. Sometimes long-term disability policies also state that you're only entitled to benefits if you're unable to perform the material and substantial duties of your own occupation, as defined by a book called the Dictionary of Occupational Titles. It doesn't matter how you actually performed your job for your employer. What matters is the definition of your job. Unfortunately, in many cases, the material and substantial duties of your job aren't at all how your job is actually performed.